Hello, good afternoon, everyone. It's 3 p.m. and our workshop will be starting soon. I would like to thank everyone who has been with us from the first session, second session to the third session. Our first session was about cybercrime and what exactly it is. So Lawrence, Mr. Dinga, the cybercrime expert, took us through that session. And then we had a second session where we're looking at digital evidence, admissibility of digital evidence, and how to gather that evidence and make sure it's admissible before court. Yeah, that session was a week ago, and it's available online. If you missed the session, it's available on the East African Law Society Facebook page and YouTube channel. Also on the Law Society of Kenya's YouTube channel and Facebook channel, you'll be able to access that information. So today is our final session. We'll be wrapping up. And Mr. Lawrence will be taking us through. Mr. Lawrence Dinga. He's a cybercrime and cybersecurity expert. He has trained judges, lawyers all over jurisdictions in cybercrime and investigate and handle it. So this is our last session. We'll take us through, then we shall have an interactive session. We request that you let your friends know that the last session is taking place. This time we'd like to also share experiences from different jurisdictions. So let's have some people join in from Tanzania, Rwanda. And without so much, I think let's let Mr. Dinga take us through at exactly 5 minutes past 3. Welcome, Mr. Dinga Lawrence.
Thank you, Amy, for the introduction. Good afternoon, ladies and gentlemen. Welcome to the third session of our continued series on cybercrime and electronic evidence. Let me just share my screen. Please confirm if you can see my screen, moderator.
Yes, we can see it. We can see it well.
All right. Okay. Thank you very much. Yeah. Now, today's session is going to be on digital forensic process. And what happens here is that you'll find that most of the things that I'm going to talk about, we've already touched. So this session is going to be a little bit shorter than the other two that we've gone through. So for those people who did not attend the first and second session, who did not get the introduction about me, basically I am a cybercrime and electronic evidence specialist. I do in forensic investigations. I'm also I also evangelize cybersecurity and awareness among legal professionals, including lawyers, prosecutors, magistrates, and judges in the areas of cybercrime and electronic evidence, as well as digital forensics. I am an expert witness in court, and I've represented in quite a number of cases involving cybersecurity and electronic evidence. I'm also a presenter in many of these national and international conferences in cybersecurity and digital forensics. And I'm a listed and approved consultant for the Cybercrime Program Office of the Council of Europe. So those who did not get my introduction, that's all about me. If you need any help from me, you can see my number is on the screen. My email is also on the screen. and my full name is on the screen. So you can take them down in case of you need any help from me, then you can just let me know, and I'll be able to help you. So basically, as I said, this today we are just going to look at the digital forensics process, and just to recap on what we had done last week. What are some of the challenges when we talk about digital evidence? What are some of the challenges that we encounter when we are trying to collect this evidence? Because you find that in many jurisdictions nowadays, electronic or digital evidence comes in many cases. So it depends on how you are going to collect that evidence, how you are going to present that evidence in the court of law, so that it can be accepted or it can be admissible. Now, some of the challenges we talked last week is that the digital evidence is invisible to an untrained eye, which means that digital evidence is normally found in places where only specialists would search in locations reachable only by means of special tools. It is not something that you can just go to a computer and do a copy and paste, because that will invalidate the evidence. So you need to have a trained eye. In short, somebody who is collecting the electronic or digital evidence must be somebody who is trained in that profession. Otherwise, when you collect that digital evidence and take it to court, and the court can prove that you do not have the necessary training to collect that evidence, then that your evidence cannot be admissible in the court of law. The other aspect of digital evidence, another challenge, is that it is volatile. So digital evidence can easily disappear by being overwritten or deleted, just by a stroke of a key. We say that data which is found in the RAM being the random access memory, which means that that is the memory in a computer which has data you are working with. Now, when you shut down that computer, that data will be lost completely. So that is also another challenge when you are talking about digital evidence. Now, another challenge is the fragility. The digital evidence is susceptible to alteration and can easily be manipulated, altered, and damaged. And that is why the process of collecting digital evidence must therefore be methodical and systematic. So, and when you go to court, you need to prove to court that the process that you use to collect this evidence, it is properly documented, it is properly scientific, it is properly methodical, and it is systematic, so that it can be admissible in the court of law. The other aspect is that the digital evidence can be duplicated without degradation. You see, you are copying a file from one device to another. You know, that file maintains its property, except that there are certain data about that file which will be changing. That is what we call metadata. That is what we explained last week. So digital information can be copied indefinitely with each copy exactly the same as the original. So it is difficult to differentiate the original and the duplicate. So only if you are a specialist in this field is when you can be able to know exactly to look, so that you can be able to defend that particular evidence. Now, the other aspect is the transborder nature of cybercrime. Now, it is possible for a criminal to be in one country, the crime to happen in another country, and the evidence to be held yet in another country. And this is so possible, especially with the cloud computing, where you wake up and you know that your mail is in your Gmail is you log into your Gmail, and yet you do not even know exactly where your data is stored. So being that it is transborder, it brings another problem of jurisdiction. If something happens, which jurisdiction has got the power to prosecute that particular cybercrime? Now, also proper procedures, techniques, and tools must be used to collect that evidence. So as more traditional forensic discipline, digital forensics specialists require special tools and knowledge to undertake their investigation. So knowledge is very, very key in this. There's a certain skill set that you need in order to help you collect this evidence in such a way that it is going to be admissible in the court of law. There's nothing which is as bad as you are collecting evidence and you are going to court with your client and you're standing there, and then somebody dismantling the evidence that is brought to court, and then you lose a case. So it is important that you know some of these things, you know some of these characteristics of digital evidence, so that whether you employ a specialist like me to help you, then actually you know what is expected of that particular specialist. So the other aspect is admissibility. So digital evidence must be obtained in compliance with the existing legislation and best practice to ensure admissibility at trial. Now, each and every jurisdiction have got an existing legislation which prescribes how that evidence should be collected, how that evidence should be preserved so that it can be able to be admissible in the court of law. Otherwise, if it does not meet certain criteria that is in the existing legislation, then automatically that evidence is not going to be admissible in the court of law. Now, we also need to recap on some of the on the divisibility of evidence we talked about last week. Now, we say that for this evidence to be admissible, it has to be reliable. So reliability must be, it must exhibit the reliability. So there must be nothing about the way in which the evidence was collected and subsequently handled that may cast doubt on its authenticity and veracity. Now, I explained this, that when you are doing this, then you need to document exactly the process that you used to collect this evidence, and whether there were some steps that were not properly conducted. You need to document, because that is what will make the court believe that the process that you use to collect the evidence is reliable. Then there is the issue of credibility. Credibility is a measure of a witness and whether or not a witness is worthy of belief. So a witness must be considered, might be considered credible if they have reliable information. And this is what we explained, that when somebody has collected evidence and they go to present that evidence in court, like me, when I normally do that quite often, what happens is that the court needs to know what is your training background. Are you trained as a forensic, digital forensic expert? What process did you use to collect that evidence? So this must become out very clear so that the court knows that the person that we are dealing with is actually an expert, and whatever he is saying, this particular witness is worthy of belief. Now, then there is the issue of validity in the admissibility of evidence. So one way to demonstrate that digital evidence is reliable is by showing that it was collected in a valid manner and whether scientific principles were used to preserve, to acquire, and to analyze digital evidence, and standards were met to handle that particular evidence. From the collection of that evidence to the preservation of that evidence to the analysis of that evidence, are the standards met? The forensic standard, the digital forensics, are they met so that we can be able to know that this evidence which is presented before the court is actually valid. Now, so that is about what we did last week about about digital evidence and the challenges and the admissibility. So what is digital forensics? Now, today, what we are looking at is we are looking at the digital forensic process. So what is digital forensics? Because we need to understand this to actually know or have the background of how we can be able to present the digital evidence. Now, digital forensics is a branch of forensic science that involves methodical application of computer investigation and analysis techniques to gather evidence found on computer or any other digital storage media. So the digital forensics process involves the use of modern technology, tools, and processes to identify, to preserve, to recover, to analyze, and present digital evidence in a manner that is legally admissible in law, in the court of law. Now, so there are two things here. First, it is a methodical application of computer investigation and analysis techniques. It's a techniques. Is more of not only technology, but it also involves the use of procedures. So apart from the technology itself that you are going to employ to collect the evidence, which technologies can be varied, but what is also important is the procedure that you use to identify that particular evidence, the procedure that you use to preserve that evidence, how did you recover that evidence, how did you analyze that evidence, and how did you present that evidence in the court of law so that it can be admissible. Now, why I'm saying so, there's a time that there's a case which I was handling, and the prosecution had brought the evidence in the in court, and they had transferred the evidence from the CD, from the original device to a CD. And then they brought the CD as the primary evidence in the court. However, the original device that they used to collect the evidence, they did not include things like the serial number. So we did not even know what kind of device is that. How does that device operate? How did you collect this evidence? There was no procedure. So eventually, the court could not admit that evidence. So apart from the technology that you are using, you have to know that digital evidence also involves the procedures which are legally admissible in the court of law. So in all this, we can say that digital forensics is actually the convergence of science and law. Because basically, forensics is just to do an investigation with at the back of your mind, knowing that you are going to bring this evidence in the court of law. So that is what digital forensics is all about. Now, if you look at that figure, you can see that the digital forensics is divided, has got many branches. Now, there's at the top there we have the computer forensics. Then we have mobile forensics. Then we have network forensics. Now, in computer forensics, this is what we talked last week. We say that there's what we call postmortem forensics. Postmortem forensics is or dead box forensics is where you are conducting collecting evidence from a computer which is off. It is not on, it is off. You go to a place, you are told that this is the computer that has got evidence. So there are procedures that you need to follow to collect evidence from that particular computer when it is off. That is what we call postmortem forensics. So sometimes we call it dead forensics. Live forensics is a situation where you go to a place and these guys cannot be able to allow you to pick the computer, because that computer maybe is being used for a very critical a critical process within that organization. So what you do is that you need to hook to that computer and collect that the evidence while that computer is running. So you're doing what we call live forensics or live acquisition. And there must be procedures that to follow to make sure that whatever you're collecting is actually collected in a valid manner. Then there is also application forensics. We have Windows forensics. We have any other application that can be there. Any application that is running within a computer. There's a way those applications are storing data, and if you need to collect that data, there must be a way of collecting that data. So that is part of the digital forensics, what we call computer forensics. And this is actually the oldest of all. Because before, when computer forensics came into being, mostly we found that only the computers had got data. So this is, if you sometimes you find it, we just call it computer forensics because this is the oldest of all the digital forensics. Now there are other devices. That's the DVR, there's the routers, there's the game console. These are all devices that have got storage, and you should be able to know how to extract data from those particular devices. Then we have mobile forensics. Now, mobile forensics is a new kid in the block, whereby we are now investigating data from or collecting data from mobile phones. And here, the way you collect data from Android is not the same way you could collect data from the iOS gadgets. So in mobile forensics, we have Android forensics, we have iOS forensics, we have Windows Phone, we have others like SatNav for the GPS. So all these gadgets, all these devices have got data in them, and you have to know how to collect that particular data or that particular evidence. Now, in network forensics, we are talking about packets or communication packets that are traversing the network, either the wired network or the wireless network, like the internet and accessing through your Wi-Fi router. Now, when you are accessing the internet, there are packets that are being sent from your device to that particular router and back and forth. Now, those packets, those communication packets have got data, have got evidence. So you can be able to capture those packets, analyze them, and be able to get evidence that you are looking for. So sometimes we call this, we have live network forensics, we have captured packets forensics, and malware analysis here is whereby you are dissecting packets to find whether these packets have got malicious software embedded in them. So that is when we talk about digital forensics, that is the branches of digital forensics. And you can see from the traditional analog, when you go to a site, you have to do what? You have to secure the site with those security tapes. On the other side, you can see that here is totally a different world. You have your CPU there, you have your monitor there. So how do you collect? The way you are collecting the evidence from analog process and digital forensics, quite different. Also, if you can see from when you are doing something on analog, you don't want to interfere with the evidence. So you have to put on your gloves and make sure that whenever, if it is maybe a fingerprint, your fingerprint is not left at the scene. Remember last week we were talking about the Lockhart principles of transference. So when you go to a crime scene, you'll take something with you from a crime scene, and you leave something of yourself at the crime scene. So when you look at the analog way of doing the investigation, you'll see that this person is putting on his gloves, so that they can be able to collect that evidence in a proper way. On the other side, when you look at the digital evidence, we talked about the digital evidence reliability. Now, if you are collecting evidence from a computer, there's no way you can just hook your hard disk and then try to extract evidence. What happens is that you don't want a situation where evidence is written back back from the gadget back to the computer. You want to keep the evidence as clean as possible. So use what we call this gadget to help you make sure that the digital evidence is not interfered with. So this is what we call write blockers. And you can see from the analog way, that is what we call the footprint. And what is the footprint in the digital era? You can see there's just the numbers, and there. Also, when you talk about you go to a place like the DCI, you need to verify whether you are a criminal or not. Then what do they use? They use the fingerprint to verify that. In digital, how do we secure our digital evidence? We use the digital process. That is making sure that the digital evidence has not been interfered with. And you're using things like the hash values like the MD5, the SHA-1 and SHA-2, or SHA-512. I think these things, we mentioned them last week when we were talking about more about digital evidence. Now, when we talk about digital forensics, what is the process? Now, digital forensics, you find that in many organizations, they have developed their own national guidelines and procedures for the acquisition and protection of electronic or digital evidence. Now, what happens is that however good those procedures and guidelines are, it creates issues when it comes to cross-border crimes. Because remember, in each and every jurisdiction, they have their own pieces of legislation that is addressing how the digital evidence is supposed to be collected. So this creates issues when cross-border crimes are committed, since digital forensics evidence acquired in one country may not be presented in the courts of another country. So this is a problem that many investigators face right now. So the process, you can see that the process starts from the acquisition to processing to analysis to presentation. I've just shortened it. And what happens here is that because we need a situation whereby I can collect evidence in Kenya and I just take that evidence to Uganda or Rwanda and I take it to the court of law. The ISO has come up with what we call the ISO 27037. Now, this is the first of a developing family of international standards that seek to create common baseline for practice in digital evidence. So if you go and Google ISO 27037, that is the first family of international standards that is trying to create that common baseline for digital forensics. Now, ISO 27037 is not meant to replace any local or national government's authority to regulate the digital forensics. But rather, what ISO 27037 is doing is that it is facilitating the usability of evidence obtained in one jurisdiction by a legal process to be used in another jurisdiction. So if we are following the ISO 27037, then probably we can collect evidence in Kenya, and we take it straight away to Uganda if that's where the case is, and that evidence is going to be admitted in the court of law. So what this standard addresses, this standard addresses the initial steps in forensics. As you can see there, you can see the identification, then there's collection, acquisition, and preservation. So the ISO 27037 just addresses the initial steps in forensic process. That is the identification, the obtaining and preservation of digital evidence. So this is what ISO 27K is addressing. So the fundamental purpose of ISO the 27K digital forensic standard is to promote good practice, methods, and processes for digital capture and investigation of digital evidence. So this tells you that if we can, organizations can follow the ISO 2737, then basically we can be able to use evidence in different countries, because every country has got its unique legislative system. So a crime committed in one jurisdiction may not even be regarded as a crime in another jurisdiction, because according to that particular country's jurisdiction, particular country's legal legislation, that may not be considered as a crime. So the challenge is to harmonize processes across the borders such that criminals can be prosecuted accordingly. Therefore, it means it's a means to allow and facilitate the exchange and use of reliable evidence, like on an international standard. So that is what actually ISO 27037 does. When we talk about the process, we remember what we've talked about here. We say that the process starts from identification, collection, acquisition, and preservation. So we are going to look at those steps one by one. So in collection, during the identification, that is the first. That's the first process. Now the process involves a search for and recognition and documentation of potential evidence. Here's a case where when you go to a crime scene, or you go to a place you are going to collect evidence, the first process is identification, which means that you are making sure that you can recognize what the digital evidence is, and document that potential evidence to make sure that what you are going to collect is actually what you need. Now, the investigator also learns what type of digital data and devices that are involved in the investigation. Here's a case, we say that digital forensics is a process, it's a scientific process. And the way you are going to do investigation when it is a mobile phone is not the same way you are going to do investigation when you find that the suspect device is a desktop. There are two different procedures. So during the identification, you need to identify what kind of gadgets or what kind of evidence or devices are involved in this particular crime, so that you know what types of tools, what types of what type of process that you can be able to use during your investigation. So this step allows the investigators to plan for tools and techniques to be used on subsequent steps. So it just that is what we call the identification. You identify first the evidence that is there, the type of evidence that you are going to find there. If they are desktop, you know that the process is going to be different. If they are mobile phone, you know the process is going to be different. And even the method of transporting them from that crime scene to the lab is also must also be you have to be very careful about that. So the importance of having the identification process is just to make sure that you can be able to plan for tools and plan for the techniques that you can use in the subsequent steps. So this process also allows the investigator to avoid collection of unnecessary evidence. Now, unnecessary evidence means that you are collecting something that you are not going to even be useful to you when you take it to court. Now, I have a nice, I had a nice story about some people who are going to collect evidence from a from a client, from a suspect. And when they went there, what did they see? They saw that the computers were on, and to them, because they were not they were not experts, instead of collecting even the CPU or collecting all the whole computer, what they collected are the monitors, and because they were arguing that whatever they saw on the monitor. So you can see it is you're collecting evidence that is not going to help you during your investigation. Now, when we come to the process of evidence collection, so the process of collection is actually the process of gathering items that contain potential evidence. Remember, what you have done here is that you've gone to a site, you've identified the potential evidence. So you need to collect them. You need to collect this evidence that you think has got potential evidence. So you need to collect all these gadgets or devices. So these devices are then transported back to the forensic laboratory or any other facility for acquisition and analysis of digital evidence. Remember here, there are two different things. Here is the collection and acquisition. Collection is actually you are collecting that particular device that has got potential evidence. Once you collect it and taken it to the laboratory, then you if it is a computer desktop, then where is the potential evidence? The potential evidence is found on the hard disk on that particular device. Now, what you need to do is now you need to connect to that hard disk and collect the evidence. That is what we call now acquisition. So you need to connect to that hard disk to a special tool and acquire that evidence. So collection is actually taking into custody the potential devices that have got potential evidence. So the investigator must have a legal authority, that is a search warrant, to acquire and collect digital evidence, because without a legal authority, you will not be able to, that evidence will not be admitted in the court of law. It will not be admissible because by the time you are collecting that evidence, you did not have the legal authority to collect the evidence. So, we saw that last week, we talked about that. So you must make sure that that legal authority is with you, because the evidence that is improperly collected is not usually admissible in the court of law. Now, when you go there to collect the evidence, the other thing that you need to know is that collection are identified based on value and the volatility of the evidence. What is the value of that evidence in your investigation? So you have to give preferences. The high value evidence must be collected first, then you collect the low value evidence. The other thing is also the volatility. We talked about that digital evidence is volatile. If you mess up with it small time, it will go. So if you find that computer, you go somewhere and find that the computer is on and you need to pick up this computer. What do you do? You say that the computer which is on has got something on the random access memory. And when you shut down that computer, that evidence that might be in the random access memory will disappear. So what you do, you need to see how you can collect the evidence in the random access memory before you actually go to persistent memory like the hard disk. Now, you need to have that process of collecting that random access memory. That is what sometimes we call the memory forensics. How do you collect it so that you don't lose that, that particular evidence that is existing in the memory? So where a device cannot be taken from the scene, like it's a critical infrastructure systems, things like live acquisition is supposed to be conducted to collect the volatile evidence and non-volatile evidence that are running from that system. So if you find, we've just talked about that previously, if you find some that we cannot collect this, this particular evidence, this particular device or this particular equipment, then you need to do live acquisition. So when illegal items or any other evidence is in plain view, it is also a reasonable for the officer collecting that evidence to seize those evidence immediately, because they can also be part and parcel of the evidence. So when you go there also, you must be able to make sure that the scene is thoroughly searched, because the possibility of anti-forensics may be existing. Now, anti-forensics is a situation where is a situation where there are processes which are running that will make your investigation very difficult, because you will not collect that evidence. For example, encryption. Now, if you go and find a computer which is on, the data is actually on the RAM. Now, when you shut down that computer without collecting that, the possibility could be that that computer hard disk is encrypted, and this happens in many organizations nowadays. They encrypt the information on the hard disk, but when somebody logs onto that computer, let's say in when they come in the morning, then the possibility of the encryption keys which are existing on the RAM is very high. So when you collect that evidence from memory, maybe you'll be able to collect the encryption keys, and that will help you later when you need to go on with your investigation. So it is very important that you have this process done properly. So powered on systems, when you find that a computer is powered on, you need to examine the computer for any running process, because they could be that the process which is running that computer is actually, you think that is a normal process, but it is destroying the evidence. So you have to make sure that you examine that computer, you observe the processes that are running, and if it is possible, if you think that it is destroying the evidence, then you need to stop that process and immediately document any action that you've taken. So I've also talked about considering the potential encryption which is on that computer, which you need to make sure that you preserve. You might need to document, you need to photograph, you need to do all the sketches, connection to other computers, so that when you come you come back to connect it, then you'll be able to have no problem. Also, when you package it, make sure that it is packaged properly in a manner that is you cannot be able to lose the evidence. Like, for example, if somebody knows that they are implicated in a situation whereby the potential evidence, for example, a phone, they have their phone like iPhone. Now, the evidence can be deleted when you are taking that particular phone to the laboratory. Even before you reach the laboratory, the suspect can delete the evidence remotely just through the iCloud. So what you need to do is, when you're packaging that, you need to use proper packaging, something what we call the Faraday bag. You put that particular device on this Faraday bag so that it does not communicate to the external world. So it is important during collection that you follow proper procedures. If the phones are on, leave them in that state that you found them. Do not actually shut them, because you may encounter something like encryption on that particular phone. Now, when it comes to evidence acquisition, remember what we say, that when you're doing collection is you are actually collecting the equipment that have got potential evidence. Now, once you collect those that have got potential evidence, then you need to now acquire that evidence from those potential equipment, those equipment that have got potential evidence. So in most cases, you find that when you're talking about computer, where is the data stored? Data can be stored on RAM, as we say, the computer which is on, which has got random access memory, so data is stored there. However, data is also stored permanently on the hard disk. Now, what you do in acquisition is that you are not supposed to work on the original evidence for analysis. That should not happen in any case. You are not supposed to work on the original evidence. So what you do is what we call disk imaging. Disk imaging is creating bit by bit copy of the content of the digital evidence, so that when you're doing analysis, you will do analysis on the copy that of that particular original hard disk, using what we call a write blocker. The write blocker is a hardware that you put between the collection device and the computer, the hard disk you are collecting, so that the evidence is not written back to the original. So that is very important. So write blocker is used to prevent the alteration of data during copying the copying process. So the integrity of that evidence must be maintained. Because when you do that bit by bit copy, it creates what we call hash value. Hash value just means that when somebody is going to test whether that something has been changed on that particular device, they compare the hash value that is going to be created with the hash value that was created during the acquisition. And if those hash value match, then we know very well that that evidence has not been interfered with. So that maintains the integrity of the evidence. So hash value is a mathematical computation, or what we call the cryptographic hash function that you run on the particular device you are collecting evidence, and you produce what we call the hash value, and you keep that hash value. So if somebody wants to verify the integrity of that evidence, they can compare the hash value that they are going to create and the hash value that you created. If they match, then that evidence has not been interfered with. And you remember when we talked about the principles of digital evidence, one of the principles we say that they need to be auditability, and so that whenever you present that evidence and the other party says that no, we are not satisfied with that, then you can give them the original evidence, so that they can also do the same process and arrive at the same value. So that is why it is important that you don't interfere with the original device or evidence. You work on the copy. So examination process should be performed on the bitstream copy rather than the original copy. So that is what is important when you are looking at evidence acquisition. Actually, you are picking the real evidence from that particular device. And this is, and that diagram shows you what I was just talking about, the write blocker. You see the person is collecting evidence from a device on the left-hand side, and is picking that on a hard disk, which is on the right-hand side, or vice versa. But what happens is that the importance of having that black device is that it is preventing evidence from being written back on both ways. It's just one way of writing the evidence. That is what we call write blocking. Now, during evidence acquisition, precautions should be taken to prevent exposure to evidence that may be contaminated with the hazardous or dangerous substances. So you have to make sure that evidence is protected. All items submitted for forensic examination should be inspected for their physical integrity, and also methods for acquiring evidence should be forensically sound and verifiable. Method deviation shall be documented. If there's any any deviation from the process that the normal process, you need to document that, and you need to show the court that I did this instead of this during this step because this is the reason. So that must be taken into consideration. So digital evidence submitted for examination should be maintained in such a way that the integrity is preserved. We talked about that integrity. Any errors encountered during acquisition should be documented. Documentation is very important here. Now, and also steps should be taken to ensure that integrity of the data is acquired. This may include one of the following, things like the hash value. I've talked about the hash value. Also stored in read-only media or sealed in tamper-proof packaging. In case it is a mobile phone and you do not want somebody to wipe it when you are transporting it to the lab. So you can put that particular evidence on a tamper-proof, what we call the Faraday bag, to make sure that it does not communicate with the external world. So there are two ways of collecting this evidence. This is what we call this physical. Here is where you use hardware or software write blockers to collect the evidence. We've seen what write blockers are, and then you come up with a forensic image, which should be acquired using the hardware or software that is capable of capturing the bit stream. In logical hardware or software write blocker should also be used. Now, forensic images should be acquired using the hardware and software that is capable of capturing sparse or logical images. Here is a case where you do not want capture the whole hard disk. So you are doing it selectively. That is what we call logical. Physical, you are collecting each and everything in that particular physical hard disk. While logical, you are doing what we call sparse or logical image of the original. You are not collecting each and everything. Now, live acquisition, we've talked about live acquisition, and we said live acquisition should be acquired using hardware or software that is capable of capturing sparse or logical image. Now, live acquisition here is very tricky. You have to be very, very careful, because if you're talking a live acquisition here, you know very well that the computer is working and is continuing writing on modifying the data. So how you're collecting that data will be you have to be very, very careful to make sure that you are not interfering or you are not adding something which is not needed on the data. So there's always ways of doing that live acquisition, and it is done when the situation presents itself and it is not possible for you to collect that machine and take it to the laboratory. So live acquisition software should be run at the highest level of privilege available to ensure that all possible data is available. What this means, that is when you are doing that live acquisition, that computer that you are collecting the data from, you must log on with high privilege. You have to log on as an administrator so that you can be able to collect as much evidence as possible from that particular gadget. Sorry, I don't know about this. Now, acquisition documentation. What is important in forensics, what will help you is documentation. Documentation and documentation. Because if you have proper documentation, then it will help you in the court of law. Now, when you're doing that, you need to, who is the examiner? What is the acquisition date? What is the acquisition details? What type of acquisition is imaging? What imaging tool are you using? What is the version number? what is the physical condition of the evidence and the unique identifiers, such as serial, description, make or model. Now, something like just serial number and description of the gadget that you are collecting evidence from can actually determine that case, because if you take and the court asks you, how did you collect this evidence? From which device did you collect evidence? What type of device is it? What is the serial number? If you don't include those things, I'm telling you that evidence will not be admissible in court of law. So you need to document each and everything. Documentation is very, very, very necessary. So that is very important. If you as a lawyer, you have somebody who is an expert and is just doing things casually, is not documenting things, be careful, because you are going to have hard time convincing the court to accept such evidence. So make sure that documentation is there. So you also need to have photograph the items. You need to verify the hash value, things like that. Documentation is very, very important in evidence acquisition. Any additional information required by the court, you need to put that in place. Then once you then there's the process of preservation. Now, preservation is the process to maintain and safeguard the integrity or original condition of the potential evidence. So when you go somewhere, you've collected that evidence, you must make sure that it is preserved properly. So digital evidence is very fragile and can be easily altered, damaged, or destroyed by improper handling. So your preservation must be taken very seriously. So evidence preservation helps assure admissibility in the court of law. Digital evidence should be stored under strict access control to protect it from accidental or deliberate modification, as well as appropriate environment controls. You know, if you collect evidence, something like on a hard disk, when you're transporting it, you have to make sure that the condition under which you are transporting that device is favorable. Otherwise, if you damage it, you lose your evidence. Yeah, I've just told you about the mobile phone. You are transporting it to the laboratory, and because you did not put it in a Faraday bag or that prevent its communication to the external world, somebody can actually wipe that evidence from that particular device. So this is what we call evidence management. So evidence management, if you can see, it needs to, there must be a procedure procedures of storing the evidence. So the procedures used to protect the evidence and document when collecting and shipping that evidence. Things like the logbook of the project, a tag that uniquely identify any evidence. So at the lowest, you must have those procedures, and this is what we normally call within the law enforcement standard operating procedures for evidence collection. You have to put in place things like the chain of custody, which we talked about last week. Also, evidence transfer. If evidence needs to be transferred from one facility to the other, at the time of the evidence transfer, both the sender and the receiver need to give the information and date and time of the transfer in the chain of custody. So you can just see how these things are serious, because a chain of custody is actually a legal document. So when you go to court and the chain of custody is not showing, you don't have a chain of custody, that evidence, the likelihood that it can be rejected by the court is very high. So in your documentation, you have just to make sure that you achieve this by proper handling and documenting the evidence. And also, the evidence management must help in protecting the true temperature of the temperament of the evidence. So evidence management is very useful if that evidence is going to be accepted in the court of law. Now, we talked last week about the chain of custody. That's why I was telling you that this particular session is going to be shorter than the others. We talked about the chain of custody. I said that the chain of custody refers to the chronological documentation or paper trail showing the seizure, the custody, the control, the transfer, the analysis, and disposition of physical or electronic evidence. From the time you collected that evidence, you started documenting it, the chronological documentation. And to maintain the chain of custody, you must preserve the evidence from the time it is collected to the time it is taken to the court, so the time it is presented in the court of law. And to prove that, the investigator should testify that the evidence that is offered in the court at that particular time is actually the evidence that was collected originally. It's the original evidence, which is very important. They also have to testify against the time, to the time and date the evidence was received or transferred to another agency or facility. They must also talk about that there was no tampering with that evidence while it was under their custody. So a chain of custody should be initiated at the time the evidence is recovered or evidence is collected, and it begins from the time of the seizure of that particular evidence. We talked about a chain of custody and last week, and what you need to know is, as a lawyer, is that the chain of custody is a legal document that demonstrates the progression of evidence from the time it was collected, how it travels from the original evidence location to the forensic laboratory, to the time it is brought to the court for case determination. So that chain of custody is very, very important, and you should be able to maintain it. Without that chain of custody, it will be difficult to convince the court. So a chain of custody is a legal document that demonstrates the progression of evidence as it travels from the original location to the laboratory, to the forensic laboratory. So what is the function of chain of custody? It governs the collection, handling, storage, testing, and disposition of evidence from the time it is collected to the time it is stored, to the testing of that evidence, until that evidence now being disposed because the case is done. That is the function of the chain of custody. It also safeguards against tampering with or substitution of evidence. Nobody can come and substitute that evidence because it is actually recorded in the chain of custody. Also, it documents that these steps have been carried out. So chain of custody, as I've said, it's a legal document. As a lawyer, must be able to be very careful when you are maintaining the chain of custody. So the chain of custody form should identify the collector, sample description, the type, should also identify the sampling and data location, any custodians of the sample. So it has a lot. So this is a very important document, and as a lawyer, you should be able to make sure that the person you've employed to do this work must maintain the chain of custody. So that's the sample chain of custody. Even last week, I gave you another version. There's no prescribed content of chain of custody, but there are certain description that you have to put there. Like for this case, when I'm filling this chain of custody, what is the case number? What is the client reference? What is the make, the model client item number 2, the make and model, the description. And down there, you can also see the time and the date, the name of the client. So this is all this information you need to collect so that they are properly documented and stored properly. When it comes to forensic analysis, because you've collected the evidence, you brought the evidence to the laboratory. Now you need to analyze that evidence. Now this phase requires the use of appropriate digital forensics tools and methods to uncover the digital evidence. There are so many forensic tools, which are some are commercial, some are open source. Now, what you need to have, you need to have at least one commercial tool, because the court always believe in commercial tools. So if you are talking about mobile forensics, the best tool will be maybe Celebrite. If you are talking about computer forensics, you could also talk about NCASE as a tool, or you could also talk about FTK. There are so many so many commercial tools, as well as open source tool that you can also use to do your analysis. But the good news is that if you have a commercial tool which is properly licensed, that will have a lot of credibility when you go to court of law. So you can use the open source tool to do analysis and do your report, while you use the open source tool just to verify whether whatever it is, what you got from your commercial tool is viable. So I've just put a site there, which you can click and go to that site, and you will be able to see some suggestion from NIST. NIST is a very good site, which has got a lot of documentation when it comes to digital forensics. You can visit that site, and you'll be able to have more information. So conducting an examination on original evidence media should be avoided if possible. We've talked about that. And examination should be conducted on forensic copies only. So the other thing also, the standard and best practices should seek to establish the validity and reliability of the digital results. So first, to be admissible, the tools and techniques used in digital forensics process must be scientific and valid. That is, they need to be proven to provide accurate results through empirical testing. And that is why I talked about commercial tools, because these commercial tools have been tested. These commercial tools have been in the market for long. So if you're using commercial tools to do your analysis, then you'll get results that are more admissible in the court of law. It does not mean that the open source tools are bad, but just if you want that reliability or that validity and admissibility from the court of law. So it is important that you use the commercial tools. Second, the digital forensic results must be reliable. That is, the same result must be obtained on different locations using the same data and tools and techniques. So if I have the same data and have the same tools, which means I can still obtain the same results. So the results should be repeatable and reproducible. And you can remember that on principle number 3 of ACPO, where we're saying that if I say, no, I can't rely on this evidence, can I give you the tools? Can you use the same tools to produce the same results? So that is what we say, the results should be repeatable and they should be reproducible. Now, results are repeatable when the same digital forensic results are obtained using the same test and test items, equipment, and laboratory, as well as operator results. Now, results are reproducible when the same digital forensic results are obtained using the same test items and as well as, but different equipment and different laboratories. So once you've done your forensic, you need to report your findings. So the report should be clear, concise, and written for the appropriate evidence. Please avoid using jargons when you are presenting the reports to to your audience. So document the scope and the purpose of the examination. Give a detailed description of the media that you examine. If it's a hard disk, you have to put all details that we talked about when you are doing the chain of custody. If it is optical media or it's a flash drive, need to put or give all the detailed description. Also, you need to document each and every phase identified for it and it's relevant in that investigation. Documentation is very important here, and I cannot stress more than this, that you need to make sure that you document each and everything. You also need to provide description of evidence that was acquired during investigation, and also you need to make sure that you provide the examiner's name and the date of examination. So this is just a summary of a good report. A good report achieves its purpose by answering questions that were set out in the mandate for investigators. Because by the time you are taking up a job as the investigator, there are certain deliverables that the client wanted. So your report should be able to reflect that. You have to, so that it can answer exactly the mandates that you are given. The deliverable that you are supposed to deliver must come out very well in the report. The report is designed to meet the needs of the decision maker. So if I'm doing a private investigator, my report, when I take it to the guy who employed me to do that, it should help him to make the decision. A decision maker must rely on the facts that were presented in the report, and the facts must be based on evidence in the file. And it must be clear and written in a neutral language so that the decision maker and other readers will be able to understand it. Do not use jargon. Do not use technical words when you are doing your reporting. That report should be done in a language that everybody who is intended to read that report must be able to understand it. So it should also be concise and must convey the necessary information. It should be structured in a way so that the information can be located easily from that report. So you must make sure that your report is actually understandable by the person who actually employed you. So that brings us to the end of my presentation today. As I said, it was shorter because most of the things that I was talking about today, we've touched on them in the previous presentation, the first one and then the second one. So most of you find that some were, I talked about some very extensively in the previous sessions, and some I just mentioned about them in the previous session. So today, just more of repetition with some new content, but you'll find that most of it we had covered in the last two sessions. So I think I'll end there and get it back to Ami. Thank you so much.
Thank you so much, Lawrence, for that wonderful presentation. Indeed, your presentation of today has been one where science meets the law. You've taken us through digital forensics and evidence gathering. You've highlighted the challenges of collecting digital evidence, which challenges cut across all the different jurisdictions, seeing that this evidence is fragile and volatile. So you've taken us through also those different tools that can be used to collect digital evidence. And there's also something that you raised about evidence that may be collected in one jurisdiction, sometimes may not be able to be admissible in another jurisdiction, maybe because of the way it has been collected. That is something that we have taken note of. You also highlighted one of the guidelines, the ISO guideline that helps with digital evidence. And we've been able to have that as a takeaway. So this session has been more to do with the collection of the evidence. And as a legal personnel who's listening in, you could be wondering, a lawyer and an advocate, but how relevant is that to me as a lawyer? But you see, the space that we are living in now is, it's an electronic world. Everything is on the internet, it's on the web. So it's unlike that you get a case which doesn't involve digital evidence. Even if you're fully practicing in the commercial space and you're not practicing in the criminal space, the chances are high that the case that you will have to handle will be dealing with digital evidence. Probably an email was sent or something was fabricated. And you need to know how this evidence is collected for you to be able to guide your clients on how to collect the evidence the right way, because you'll find that most of the cases will be failing in court just on the basis of how the evidence was collected. And also, if you're defense counsel, you could find that you could win your case just because you know how digital evidence should properly be collected, and you could be able to challenge that matter in court on that basis. So it's been a very fruitful discussion where science meets the law. And as lawyers, we need to upskill in that area to be able to understand the digital forensic tools, how, and also the reports that are written and how they are presented. Thank you so much, Lawrence, for sharing your expertise with lawyers all over East Africa. We have people from Uganda, from Kenya, from Tanzania, from Rwanda, from Burundi listening in. And we are very pleased to learn from you. So like we said, there have been other previous sessions that have been going on. The first session was generally on cybercrime, what it is, and the different offenses that are provided for by law. And it's available on the East African Law Society page. So you could go to the East African Law Society YouTube channel and be able to follow what we discussed. And also you could go to the East African Law Society page also, and also the Facebook page, the YouTube and the Facebook page, and be able to share what we discussed earlier. So I've been your moderator, and we shall take a few questions. I would also like to thank the East African Law Society and the Law Society of Kenya for organizing such an insightful workshop, saying that this is the future of the law. We would really appreciate you for being forward-looking, for having organized this workshop. And I would like to thank the CEO, Mr. David Singano, for the mobilization and everything you've done to make sure that this workshop takes place for over a span of 1 month. We've had 3 sessions, online sessions, and would like to thank the participants also. Thank you for attending all the sessions of the workshop. And also would like to thank our trainer, Mr. Lawrence Dinga from Kenya. Thank you for sharing your insights. And I work with being your moderator. We had other moderators, but unfortunately they have not been able to join us. But I've been your moderator for the sessions. I work with legal mark advocates in Uganda, and we are a commercial law firm, but we also handle financial cases of financial crime and cybercrime. Yeah, so thank you so much. I noted one of the questions in the feed. Lawrence, someone was asking about the ISO that you're referring to, that does it compel other jurisdictions, or it's just a guideline for different jurisdictions? Maybe you could highlight on that. Thank you.
Okay, the ISO 27037 is not a mandatory. I remember what I said, that each and every jurisdiction has got their own pieces of legislation. And in most jurisdictions, you may find that whatever is illegal in Kenya might not be illegal in Uganda, because it is not prescribed in our piece of legislation. However, when it comes to digital evidence, here is a case where we are saying that a crime is between two jurisdictions, and the evidence is found in Kenya, or the culprit is found on Kenya, or vice versa. So the ISO 27037 is just a recommendation that if everybody was following ISO this standard, then you can actually collect and process the evidence in Kenya, and then just go with that evidence regardless of the legislation in Uganda, and present that evidence in the court of law. So it is not something mandatory. It is just a suggestion. It is just a recommendation that if it is followed worldwide, then we can have that uniformity in evidence collection and presentation in the court of law in any jurisdiction. Yeah, thank you.
Thank you so much, Lawrence, for that clarification. Yeah, if there's anyone who would like to also share their experience with handling cybercrime cases in any other jurisdiction, we could give you some minutes, and you raise up your hand and you could share with us. This is our last session, and probably the East African Law Society will organize some more sessions like this, seeing that where we are going, it's a digital world, and we probably have to find ourselves always having to adduce digital evidence in courts as lawyers. So if there's anyone who would like to share their experience from any other jurisdiction, kindly raise your hand, and we shall let you speak. And I'll keep reminding you that in case you missed any of the previous sessions, please go to the East African Law Society YouTube channel. Just subscribe to the YouTube channel. You'll be able to find all the previous sessions that we've been having. All the information is there. And some people are asking how they get the slides. I believe the East African Law Society has registered your emails since you registered for the training. They'll probably see if they can send them to us. But all the information is available on the East African Law Society. It's available on the East African Law Society YouTube channel. Kindly get on the YouTube channel. You'll be able to get the information that was shared. So we shall just give it a few minutes. If anyone's hand is up, they could share their experience. So probably, maybe I could ask Lawrence, you've shared with us the tools of digital evidence gathering, and in most jurisdictions, we see that this is more like a reserve of the institutions that have investigative powers. For example, like in Uganda, you could find that most of the evidence gathering when it comes to digital evidence, because our laws require that you have court orders, find that it's most likely the police that will do 90% of it. And private institutions have not yet been able to develop that capacity to be able to collect that evidence. And even if they could, you find that at the end of the day, they still have to engage the institution that is mandated with the investigative powers, which for us is our Uganda police. So maybe if you could share with us the experience in Kenya. Can a private entity or a private individual be able to gather that evidence probably without a court order, or could they get a court order maybe in a civil case and be able to gather that evidence by themselves without having to go through the institutions that have investigative powers like the police? Maybe what's the experience in Kenya? Thank you.
Thank you, Ami. Now, myself, as I'm talking to you, I do investigation. Even yesterday, I was at one of the universities in Western Kenya collecting some evidence. Now, when I was contracted with by the institution, what they are looking for is for the disciplinary intentions, which of an employee from that institution. There are some malpractices that were conducted in procurement, and the evidence is actually found in the computer. So I went to collect the evidence. What I'm trying to say is that in many jurisdictions, there are people who are private investigators, people like me, who can do that job work for you, depending on who is going to consume that particular report. If it is for internal, you don't want it actually to take it to court. Then you can just get somebody who is experienced, who can collect that evidence. However, when that evidence is supposed to be taken to court, the person who actually collected that evidence must now become an expert witness in the court of law. Now, that is on whether it is private or whether it's a criminal case. Now, in a criminal case, normally it is handled by the law enforcement. However, there are certain instances where law enforcement may be overwhelmed, and then what happens is that they contract a private investigator who is going to do that work, and then once you've done that work, you present that report to the investigating officer who is concerned with that case, and now the investigating officer will take that report now to the prosecution. Now, still, when it comes to going to court, the person who did that, whether you are a private investigator, provided it's you who did the investigation, who collected evidence, who analyzed the evidence, you have to go and stand in the court of law and be an expert witness. So in Kenya, it is both ways. The law enforcement are tasked with the investigation. However, private investigators can also do the same work that the law enforcement is doing, depending on who is going to consume that report. If it is going to be to the court of law, well and good, but still, what happens is that the person who did the work must be an expert witness. I don't know whether that answers the question.
It does, Lawrence. Thank you so much. We have here another question. I'll probably chip in a bit, answer a bit of it, and then leave you to answer the rest. Someone is asking, how do I get digital evidence to be accepted by a jurisdiction in a case where there is not yet any legal authority or instrument to get this applied? What I understand from this question is they're saying if a country does not have a particular law that governs that kind of evidence, how do you get this evidence to be accepted? As a practicing advocate, I believe that even if a country does not have a specific law, at least most jurisdictions have the Evidence Act. As much as the Evidence Act, most of the Evidence Acts of different countries were created after the colonial times and are based on that, they have some principles of evidence that cut across, where most of the principles of evidence are authenticity and also making sure that the chain of custody has not been broken. And you find that some countries have case law, which necessarily they may not have written law about the admissibility of this evidence and digital evidence, but they have case law that has highlighted over time, how that evidence can be handled. But one of the principles that cuts across is authenticity, and also that the chain of custody has not been broken. How has it been extracted? Is the chain of custody very clear? That is how, if that evidence is presented and those things are proved, then you find that the courts will accept them. So in your experience, probably Lawrence, you could share, in a country which doesn't have a specific law talking about digital evidence, which I would think for most of the countries would be the Computer Misuse Act. How do you think this evidence can be presented before courts?
I think, Amy, you've just answered that question very, very efficiently, because what happens is that in many countries, even before they enacted the specific cybercrime and computer misuse law, there were pieces of legislation that they could actually use to handle digital evidence. In Kenya, even before we passed this in 2018, we had the Evidence Act, which stipulates how evidence should be handled. There are some in Uganda, I believe that there are pieces of legislation like electronic transactions and things like that that can be used actually to handle digital evidence. So, but what is important is that the principles of the digital evidence should be maintained, and chain of custody is very important. That's why I was stressing for the maintenance of that case chain of custody. Because what does chain of custody do? It just makes sure that you can convince the court that that evidence is what you collected originally, and nothing has actually interfered with it. And even the way you collect, you analyze it, it can be proved that actually it is the original evidence. So I think from your answer, you actually answered that question properly.
Thank you, Lawrence. Other question we have here is that if a phone is stolen and it's using GIS and the owner is able to track it, how should police support a non-police, meaning an individual, to adduce evidence in court to be able to get the phone back? And also, what software is used for tracking digital stolen equipment?
I think that there are quite a number of software that can be used to track digital, a phone that is stolen, even though what I know that as much as they exist, it still also becomes very, very difficult to get that phone back in my experience. However, once you can be able to get that phone back, then you'll use the same process of acquiring evidence from that phone so that you can bring it to court. But I don't have any specific software that I can say this is the software that you can use. I think that, what you can do is you can do a Google search, and you'll be able to find many software that can be used to track a mobile phone which is lost. That's how far I can answer that question.
Thank you so much, Lawrence. Maybe one last one. You see, commonly right now, the kind of digital evidence that we're having introduced in court, most of it is emails or information extracted off a phone. In a nutshell, if you could just run a lawyer through how can they quickly do that, but in the right way, without using so much scientific language, the things they should look for if someone is going to present an email, or if someone is going to present information got off a phone, because in some cases they ask for the device to be produced. So how can they be able to present that evidence? If you could run through a bit faster.
First of all, I'll start with email. And I think if you check our previous session, we talked about email authentication. And we said that, and I even showed a case which was about email authentication, which means that before that email is acceptable or admissible as evidence, then somebody who is an expert should be able to authenticate those emails, should be able to ensure and convince the court that the mails that you are presenting as evidence are actually the real emails. And I gave an example of how you can authenticate an email. What I said is that, and as email moves from from your computer, it goes to a server somewhere. And that server is acting as the post office in the normal delivery of the snail mail. So when you send an email, it moves from your computer to a server, and then for onward transmission to the destination. And within during that process, each and every server is logging the details of that email. So when you come to court with that email, before it can be admissible, what needs to happen is that you need to prove to the court that that email actually moved from this person's computer, and that is where you come with the evidence that the computer that actually generated this email is this particular computer, this is the serial number, and this is the IP address. However, to establish exactly who was sitting at that computer at that particular time is more of now another investigation process. But what the court will need is that, is this mail authentic? Did it move from this, which device generated this email? How did it move? So if you can provide that to court, then that is what we call email authentication. And it is very important before that email evidence is acceptable or is admissible in the court of law. I think you check the previous session, you'll find more, because I talk a lot about email authentication. What was the other part?
Besides email, sometimes they ask for production of their device. Any other information extracted from a phone? If they don't have that device, would that evidence still stand?
Remember what we say, that when you are doing investigation, what you need is that you do not need to work on the original device, because one, if you go, remember the ACPO rule of the third ACPO rule, which talks about auditability, and the third party can be able to use the same method and arrive at the same results. So it is important that that device, the original device, is brought to court. Now, if that device is brought to court, then we know that we can also use that device and do forensic analysis, and we'll have the same result. Now, this is something which I encountered in 2019 in a court of law, and that actually made the case to flop from the prosecution side, because they did investigation. They brought the gadget, the device, to the court of law, and when they brought it, this is the case I was saying, that the device did not have the serial number. The device did not have the model. In their report, there was no mention of the name of the manufacturer of the device. Nothing was mentioned. And then when they brought the device to the court, which it was supposed to be part and parcel of chain of custody, then they later came and took the device, saying that this device had got some more evidence that they wanted to use. So at that particular point, they broke the chain of custody. And that now cast doubt onto that in that evidence that you are bringing to court. So it is important that the original device is brought to the court of law. Thank you.
Thank you so much, Lawrence. Maybe one last question that we have here. Someone is asking, where can they undertake a digital forensic course in Kenya?
Yeah, in Kenya we have I think, how many universities? 3 universities that I know. There's the KCA University, which is offering BSc in computer forensics with a bias in for computer forensics as a special subject. Then we have also Jaramogi Oginga Odinga University, which is offering BSc in forensic computing and security, something like that. We have also some universities that are offering maybe Bachelor of Science with bias to information security and digital forensics. So there are quite a number of colleges where you can actually take this course of especially institutions of higher learning. But if you need more information, I think what you can do, you can inbox me, let the person inbox me, then I can give him or her more information about how they can start a career in digital forensics.
Okay, thank you so much. They have clarified, they're saying that the certifications, they talk about certifications, but we're going to share your number with them, be able to reach you and discuss more. Would like to come to an end of this cybercrime and evidence tools workshop. It's been an online workshop, and continue to thank you for being part of it. Would like to thank Lawrence, Mr. Dinga Lawrence, for taking out his time to be able to train us all over the jurisdictions, Uganda, Kenya, Tanzania, Burundi, and Rwanda. Would also like to thank the East African Law Society. Thank you so much for organizing such a training. Would also like to thank the Law Society of Kenya. Thank you so much for organizing the training. And would like to thank and recognize the CEO of the East African Law Society, Mr. David Singano. Thank you so much for organizing this online workshop. And thank the participants again. So with that, would like to hand over to Mr. David Singano. He could give us closing remarks and then. So in a while.
Thank you very much, Amy. I don't know whether you can hear me and see me.
Can hear you, but we have some.
Perfect. You can now see me. Thank you. Well, you have done really excellently in this webinar. I must say I was right, and the team that proposed to have you have the session done excellently. And of course, Lawrence, our presenter, is an expert area. For those that have followed us through the 3 days, I believe you are now semi-experts in this area. Amy, I hope I can be hard. I can chat. My audio is not very good. Well, let me proceed. I was thanking the presenter for an excellent job done. I know we will engage you again, Lawrence, for this training in the future. We are hoping that we're going to open up for physical training sessions. I would also like to thank the participants, everyone that has taken their time to be with us for the 3 very deep sessions that we had. And the Nairobi branch of the Law Society of Kenya. I would like to thank the chairman, Mr. Eric Theory, and his team who have organized these sessions. We really appreciate your support, and we look forward to working with you more in training of this nature. I'm sorry if my network is not very good today, which will affect my audio. But that is it from me. Thank you very much. We look forward to welcoming you again in our future training. We will make available the presentations to our YouTube channel, and we will also share some of the available slides by the moderator or the presenter today. And so be on the lookout through your emails. You will receive updates of this training. We are trying to see if we can escalate this into a certified course in the future, so that once you complete, you can do an exam and you give your certification. So that is something that is under development by the ELS Institute. So be on the lookout for a course of that nature, which might be coming in the future, so that we certify you in the area of forensics and cyber law. So thank you, everyone. Thank you, Amy. Thank you, Lawrence. I wish you all a lovely evening, and be on the lookout for the slides. Thank you.
Okay, thank you, everyone. Just a reminder to keep safe. Please put on your mask. Please put on your mask, wash your hands, and sanitize. And bye-bye from us.